Hello, everyone. Eric Olsen from Helps Law Firm for Seniors and Disabled Persons. Today, Monday, what is it? March. Get my glasses on. I can't see. March 23rd. Good to have you here. My name's Eric, attorney for 48 years, the founder of Helps. Helps is a national law firm. What we do is we represent seniors and disabled persons who owe debt they can't afford to pay in order to stop collectors from harassing them. And we educate seniors how they can maintain their financial independence. And we have this YouTube Live Monday through Thursday where you can ask questions on the chat feature, and I talk about things that clients have called in or emails or notes from paralegals from Helps about people in their situation. Okay. Some of the things you're going to hear from me today, you may not hear other places. There's almost a concerted effort to keep the fact that a senior's income is protected, their pension, their Social Security, disability, VA benefits, IRA, 401k, it's protected by federal and state laws. It can't be taken from them. And it's available for their new needs, for your food, for your medicine. And if you're in a situation where you can't afford to pay the debt, you don't have to pay the debt. Okay, you can stop paying it. Now, what happens if the creditors call you? Well, there was a law passed in 1978 called the Fair Debt Collection Practices Act. That law provides, among other things, if you're represented by an attorney, debt collectors have to communicate with the attorney, not you. And when people find out about Helps, we talk to them, we explain to them what we do, and when they enroll, they give us the creditors they owe money to, then we send a cease and desist letter, and they leave you alone. That's what we're here for. So I'll start out by talking with someone I just got off the phone with a few minutes ago, a nice lady from New York. Okay, a typical person that we help, and age is 75. She gets Social Security, a pension, and a little bit of alimony. And she has a home that she's buying. She owes about $100,000 on it. It's worth about $175,000, and she has upwards of $10,000 in debt, and she's making a car payment. And when she bought the car, it just prevented her from being able to pay this credit card debt. And so she found out about us. She was looking at our YouTube videos and called, and I happened to pick up the phone and talk to her. So I asked her about, you know, how much she had in debt, if she was being sued, how much she owed on her home, was she buying a car, your make and model of the car. Explained to her why her car is protected, why her home is protected. No one can take it. The fact she doesn't need to pay the $10,000 plus in unsecured debt that she owes. She mentioned that she has a Discover card. I said, Discover is more likely to sue than another creditor, but it doesn't matter if they sue. You're not going to have to pay it. And that if you owe Discover, that's not a reason you should continue paying it. Although she said to me that she had a couple store cards that she wanted to keep. And she listed them out, and we took a few minutes, and I was able to type in the name of the card and the credit card backed by which bank. And it told two of them were backed by Synchrony and one by some other bank. And I told her, I said, as long as you don't have another card that's backed by Synchrony that you're not going to pay, you could keep those two credit cards backed by Synchrony. And a third one she wanted to keep was another store card backed by a different bank with whom she had no other loan. So if you have a debt that you want to keep, like a credit card, in bankruptcy, whenever you file bankruptcy, all your credit cards are shut off, whether you owe them or not. Bankruptcy credit cards subscribe to a service that lets them know if someone filed bankruptcy, and they're going to cut your credit off. Not with Helps. If you have a credit card that you want to keep, as long as it's not backed by a bank with whom you're not making another payment, you could keep that credit card. So she'll be able to keep those store cards if she wants to. I did mention to her, if it later became difficult for her to do that, she could always add those in. Okay. And then enroll her in Helps. And she wanted to know, well, I have a payment next week. She wanted to know, do I need to pay that? I said, absolutely not. She acted a little bit surprised. Okay. Uh, but no, when you enroll in helps, we do it over the phone. Okay. And I click a button and we keep you on the line, and you're going to get an email from us confirming you're a member of helps. It says, and it's a fairly long email, tells you how to get us the creditors, has all our contact information, address, phone number, email addresses, our fax number. We have a text number, so you can text us the creditors. All we need is a name, address, and account number. We don't need a balance. So, yeah, we enrolled this person, and I think they were relieved to not have to worry about this. And the one thing we always tell our clients, new or not, is if you ever have a question or concern or worry, you pick up the phone and you call us. See, most attorneys, you hire them to do a specific thing, and then they're done. But with helps, you're a client literally forever, so you don't have to deal with creditors. Again, the cost is minimal. Most person pay would be $40 for 24 months, $20 for 24 months, free thereafter. Payment won't begin until, you know, at least a month to 2 months away. In this person's instance, she got her Social Security on the second Wednesday of the month. And so I told her payment wouldn't begin until May 15th. 15th would always be after the second Wednesday. And she said, oh, shouldn't it be in April? Well, I said, today is March, 23rd. It's April 15th will be less than a month. So no, the payment won't be due till May, but you'll be enrolled today. And she is. And so I clicked the button and she got an email from us that says, welcome to helps. One thing we talked about is she had a home that she owed $100,000 on, and wasn't too sure about what it was worth. Cute little house. We looked it up on Zillow on the internet, and it says it's worth $175,000. I explained to her, and I'm going to explain again, and she may be listening to this. Sometimes we'll tell our clients, we have an email that talks protecting a home for children. It is possible in a lot of states to maybe consider adding your children onto the home as joint tenants with rights of survivorship. That means you would own the home with your children together. In her case, she had 3 daughters, and there'd be 4 of them. That means if she passed away, and she's going to pass away before her daughters, then the property would automatically go to her daughters. There wouldn't be any probate. Now, the daughters would still have the debt on the mortgage, okay? But if some creditor sued her in the meantime, when she passes away and she owns it jointly with her daughters, the property automatically goes to the daughters, and any judgment lien goes away. So the daughters could immediately put the property up for sale and collect the excess equity out of the home. Now, if there was no equity, they could just let it go back. They're not going to be responsible for it. They're not on the loan. It won't affect their credit. Don't have to worry. And we sent an email to her that we call Protecting a Home for Children that describes in detail how that's done. And a lot of times you can do it yourself. Now, that's not always the case in every state. There's a few exceptions. But anyway, that's what helps does. And now she doesn't have to worry about this debt. She can make her car payment and be at peace without having the creditors bother. In fact, I think that's the title today, Overwhelmed by Debt. If you're overwhelmed by debt and you're a senior, helps us listen to what we have to say, okay? So Jerry says, Eric, if a creditor voluntarily dismissed their case, can you request them to drop their lien also? Well, they won't get a lien, Jerry, until they sue you and get a judgment. So if they drop the case, which happens occasionally, they drop it before they get a judgment. Once they get a judgment, there's nothing to drop. They've already got the judgment. So in that case, if they drop the case, if they sue you, sometimes we'll sue and we'll send A client, sometimes a client gets sued. They send us a letter, or they send us a copy of the lawsuit, and then we'll send a letter to the attorney that sued our client, letting him know that the client's income is protected. They can't afford to pay the debt. We understand they're going to get a judgment. And sometimes when that creditor gets that letter, uh, the creditor attorney decides to drop the lawsuit. Not often, but it happens enough that we hear about it. So if they were to do that, yeah, then there's no judgment. There's no lien. There has to be a judgment before there's a lien. When a person has a home that was in the Miss H acts, if a person has a home that was in the mom's name and the lien was on that home from the daughter having work done, the mom passed away, did the lien drop off, or will the daughter get the home? Need to know a few more facts. So if the mortgage was in the mom's name and the daughter had work on the home, um, it would depend on a few more questions I'd have to ask to be able to tell. Will the daughter does the lien drop off? There normally wouldn't be able to be a lien. The lien was against the daughter's home that was paid off, not the lien on mom's home. Okay, so okay, I think I understand. The question is this. Okay, mom has a home, daughter has a home. Okay, mom dies and the home goes to the daughter. Daughter has a home that she's buying, and apparently there's a lien on that, probably a judgment lien. So I'm going to sue the daughter and got a lien. Okay, a judgment can be a lien on the real property, normally in the county where the judgment's located. So if mom and daughter live in the same county, then if daughter has a judgment lien against her and then she gets an inheritance of mom's home, either by transfer of the deed because the mom joined the daughter under the deed, or by a probate, then yeah, the judgment lien would transfer to that home that she got in her name. Okay, we can talk about that with that person in more detail, but that's essentially it could very well, the lien could very well transfer to the daughter on the home that the mom gave to the daughter. Hope that was the right fact situation that I shared with you. But that's something like that we'd want to talk to you in person. Okay. Person from Virginia contacts us and they say, I'm 62 years old. I have over 60,000 in credit card debt I need your help with. I'm overwhelmed by it. I recently went through the IRS tax relief program with the tax resolution company, which cost me $3,000 and got me nowhere. Most of these tax resolution companies for seniors are just ripoffs, honestly. Okay. Uh, even for younger people, they're ripoffs. I was declared currently not collectible, meaning I still have to pay the $14,000 in back taxes, which continues to accrue interest and penalties. Well, let me stop right there. If you're on currently not collectible status, that means the IRS isn't going to collect from you. Now, sure, you may still owe the tax, but the IRS has 10 years to collect the tax. After the tax is over 10 years of age, it goes away. Okay, let me go on. And the IRS has put a lien on my condo, which I own no mortgage. Well, okay, they could put a lien on it if you're currently not collectible status, but once again, after 10 years, that lien's going to go away. You're not going to owe the tax. Let me go on. I purchased it from my sister's estate when she died in 2014. I was her unpaid caregiver for 4 years. I had to use credit cards to survive during that time, which put me in greater debt than I've been. I could only afford to buy the condo because my dad died 3 weeks later, so I used my inheritance from his estate to buy the condo so I'd have a roof on my head. I don't know if help's going to assist with that, with my tax burden either, But just wanted to let you know that's part of my financial situation as well. If you're on currently not collectible status, you're not going to have to worry about the tax, and the lien is going to go away after when it's been 10 years from when the tax was due. Okay, so maybe the tax was due back in 2020, let's say 2018. Okay, um, but they didn't put the tax lien on until 2020. Is it 10 years from 2020 or 2018? 10 years from 2018 from when the tax was due. Then the tax will be uncollectible after 10 years, um, and the IRS will remove the tax lien. I hope to hear from you soon. I appreciate what you do. I have a friend who you help. So we'll call this person and go over it with him and be able to help him. I've requested your mail info, but would welcome a call, text, or email as well. Okay, yeah, we'll be able to help this person. So Ms. H asks about um, Form 982. Okay, so let me explain that. Um, if you owe debt and you don't pay the debt for a credit card, for example, technically the credit card company, when they write off the debt, they're required to send what's called a 1099-C, which is an IRS tax form to the IRS that lets the IRS know that you didn't pay that debt, and therefore the IRS should consider that as income to you on which you have to pay taxes. Okay. Now, if you're not required to file tax returns, you don't need to worry about that 1099-C. Okay. But if you are required to file tax returns, you can file what's called a Form 982. And one of the boxes is if you're insolvent, which means if your debt exceeds your assets, then there's no tax. Okay. And that's, I think, box 1B. You check that box. What does that mean, insolvent? That means, let's say you had an old car, household goods, everything was worth $10,000, but you had $50,000 in debt. Well, you're insolvent, which your debts far exceed your assets. There's no taxes. But once again, if you're not required to file taxes because your only income is Social Security, you don't even need to worry about Form 982 or tax lien or filing taxes. Okay. I'm sorry, I was laughing at what Robert said. He says, I'm a member of HELPS and I've tried to get through the IRS to hopefully get on non-collectible status. I cannot reach anyone by phone and have tried endless times. I'm completely frustrated. So what I'll tell people sometimes, okay, um, you may not need to get on it's called currently not collectible. Okay. Um, non-collectible, same thing, but currently not collectible. Um, the most the IRS would do if you owed money to them, if you're a senior normally, would send you a letter saying after 60 days, they're going to offset 15% of your Social Security. I don't see them going after people's pensions, IRAs, or 401ks or anything like that. Now, legally they could, but they don't do that. Okay. They might do that with some peculiar taxpayer with a huge amount of taxes or a really unusual situation. But normally they would just send you a letter saying they're going to offset 15% of your Social Security after 60 days, which would give you plenty of time to contact the IRS to get on currently not collectible status. You might be on the phone waiting for an hour or two before you get them on the phone. Okay? But, you know, now, if you're paying the taxes, if you've got a payment arrangement and you're paying the tax, and all of a sudden you realize I can't pay it anymore, and your only income is Social Security, or pension, you could just choose to stop paying the tax, stop the automatic payment, and IRS may never come back to you and say they're going to offset 15% of your Social Security after 60 days. They may never do that. The computer system shows them what your income is, and maybe the computer tells them, hey, this person has such a small income, they're going to qualify for currently not collectible status. We're not going to try to collect from them. Okay? That might answer your question. In other words, you don't have to apply for currently not collectible status unless you really need to, okay? And it can get frustrating, I agree. But hopefully I can take away the frustration by letting you know that you may not even need to do that, okay? Person contacts us from Louisiana. Louisiana is a nice state. I became disabled when I was 55. I had long-term disability that was 60%, 67% of my old income. That stopped at the age of 66. Now I'm only on Social Security. Um, I got a lot of credit, but I cannot pay any of it anymore. I have not done any contact to anyone for years. I need help. I do not answer my calls unless it's on my contact list. Uh, I had surgery. Shortly after the surgery, I had a stroke. As a result, I have some problems with writing and speaking. If what I'm writing does not make sense, please question me about it. It makes complete sense. Um, yeah, if you've got medical issues, a stroke or anything, and you have questions on your finances, please call us. We'll go over it with you. Um, we're really kind to people. We can answer your questions, and I promise we'll be patient, and you'll be glad when you talk to us. My dad had a stroke when he was 58, and he lived till he was 74 or 72. I can't remember. A long time. It was hell on earth for my dad. It was a very serious stroke. He couldn't walk. Affected him a lot. So if you've got a medical, and we're happy to talk with seniors and maybe their kids if they want to. We're happy to talk to kids and about a parent's issue. Okay. So Jerry says, greetings, Eric. I'm a member. I've been dealing with a creditor for over 3 years. Helped send them the letters you mentioned, and I recently received a voluntary dismissal. I was so relieved. So Jerry got sued, and that credit, and then he got us a copy of the lawsuit. We sent a letter to the attorney letting him know that his income was protected, and that attorney, out of their own, they dismissed the lawsuit. They decided it wasn't worth pursuing, and that, like I said, that can happen. Okay, not always, but it really doesn't matter. You know, if you're getting protected income, you could be sued by 100 different creditors for $100 million. All your income is protected. Your bank account's protected. You're not going to have to go to court. You don't need to worry, and you can always call and talk to us. So you shouldn't anticipate or live for the hope that they're going to dismiss a lawsuit. It really doesn't matter because they can't take anything from you. Okay? So this person contacts us from Pennsylvania. Says, I'm 70 years old and in credit card debt and personal loans of around 150,000. That's a lot. Doesn't matter. I'm I'm using all our savings hoping to save good credit, but I'm on the last of the savings. Probably wasn't a good idea. Soon I no longer own a home. I do pay rent and I'm still up to fate on everything but sinking fast. Wife and I have 2 cars that are paid off and I need help. Well, you probably didn't need to use the money from your savings to keep on the debt because all you're doing is paying the interest. And once the savings are gone, that's your little nest egg. It's gone. If you're doing that, you don't need to do that. You can stop now and use and have that money for a rainy day for your needs. Um, are they going to? He's got 2 paid-off cars. Are they going to take your car? You know, every state has exemption laws that protect a certain amount of equity in certain types of property. It's not the practice of consumer judgment creditors to go after people's cars. I mean, theoretically, it could be done in certain instances, and it happens very rarely. We'll go over that with you, but you shouldn't really worry about that. So William asked me, my 20 days has passed to respond to a summons. I didn't. What can I expect to happen now? Thank you. Good question. Well, just because 20 days happens doesn't mean that they're going to get a judgment on the next day. That's what they're eventually going to get, is a judgment, and it's called a default judgment. A judgment is a judgment is a judgment. If you go to court and you contest the matter and the court rules against you that you owe the debt, that's a judgment. The default judgment is if you get sued and you don't file an answer, then they get a judgment by default. It's the same thing. It's a different type of judgment, but it has the same effect. It's a judgment. Now, if you haven't filed an answer within 20 days, it might be, I wouldn't be surprised if it was 2 or 3 months later that you find out they got a judgment. The court systems normally don't act that fast. Okay? I've had people call me and tell me it took 2 years before they got a judgment. Okay? They didn't do anything about it. Okay? It depends on the state and the particular court. But once again, your income's protected. It doesn't matter if they get a judgment. Okay? Okay. Person contacts us from California. What about mortgage issues? Big money ask. You know, our main mission is to protect seniors from debt collector harassment. We also educate seniors about their financial independence. So we'll talk to people about mortgages and what they can do. Okay? We're happy to do that. Okay? Before I started HELPS back in 2012, I probably filed 30 to 40,000 bankruptcies. So I know the law, and I know a lot about mortgage and mortgages that are in default. I know a lot about reverse mortgages. I know about foreclosure, what happens there, and what you can do. So William asked, will I eventually have to appear somewhere if they get a judgment? Highly unlikely. Okay, I'll explain why and when you might have to appear. You having to appear would almost be like a hen's tooth. It just really okay. If you get a judgment, we send a letter to the attorney who sued you, let them know that your income's protected. Now, it's theoretically possible that a judgment creditor could ask you to come into court to answer questions about your assets. That's called a debtor's exam. But that happens very rarely. And if it were to happen, we send a letter to the attorney who requested that. We give them proof of your protected income. We ask them, do you really want them to come in? It seems like it's going to be a waste of their time and your time, you, the other attorney, to do this. And almost always they say, yeah, you're right. I'm not going to come in. I'm not going to make them come in. So no. So if you have a foreclosure scheduled, you can come and talk to us. There's options. We could possibly send you to a bankruptcy attorney. You could file what's called a Chapter 13 and stop a foreclosure, and gives you 3 to 5 years to catch up on the missed mortgage payments. Okay? Or, just call and talk to us and ask to speak with one of the attorneys that helps. Okay, Eric, I signed up with HELPS 10 years ago. Everything was okay until the pandemic. Now I'm on up to 13,000 of credit at 31%. Looks like I have to start over with HELPS. Should I call? You don't need to feel dumb. No, yeah, call and talk to us and we'll go over this with you. Okay? You technically still may be a client of our HELPS. I got the Synchrony Bank lawsuit papers on Friday. They filed in the court the next county over. Well, they're supposed to file in the county where you reside, and you could make a ruckus because of that, but it's probably not worth the effort. If you're a client, Tater, you get a hold of us. We'll send them a letter to let them know you're not going to pay it. You don't need to worry about it. You can call and talk to us, and we'll go over it with you. Yeah, Chapter 13 will stop a scheduled foreclosure. Absolutely. And it gives you, let's say, for example, you're $10,000 behind on a mortgage payment. In a Chapter 13, you resume making your regular mortgage payment. If you're 10,000 behind, then you have to make a payment to a trustee who, for a period of 3 to 5 years. Only one of the problems with the Chapter 13 is the fees are pretty expensive. It could be $4,000 or $5,000. Now, you usually don't have to have that up front. A lot of attorneys will take that within the plan. So, and then there's a trustee commission of about 10%. So you might end up with a $350 payment in addition to your mortgage payment, but it depends on the facts. Okay. We have emails that talk about bankruptcy versus helps. Once again, we don't file bankruptcy for people, but we're certainly willing and able to tell people when they should go talk to a bankruptcy attorney. Signature Bank charged me off. 1 year later, they gave me an Amazon credit card with 4,500 line. Not surprised. You know, we do have a program, 7 Steps to a 720 credit score, where you can rebuild your credit with helps. After you've been a part of helps for 90 days, get a hold of us. Can a paralegal file Chapter 13? No. You want an attorney that specializes in Chapter 13. It doesn't cost anything to talk to an attorney about your situation that does bankruptcy. Okay? And like I said, most attorneys that file Chapter 13 can file it for minimal amount up front and build in the attorney fee in the Chapter 13 plan. Whether it's a good idea or not depends. A large percentage of Chapter 13s end up getting dismissed. Okay? But we're happy to go and talk to you about your situation. The attorneys that work at Helps have decades of experience in bankruptcy. I'm not talking about 10 years. I'm not talking about 20 years. I'm talking about 30 or more years. In my case, 48 years. Okay. Our practice isn't going to end. Yeah, the 720 class is pretty much doing it on your own anyway. You got to be patient with it. Yeah, tempting to spend. You don't want to go. Yeah, right. Okay. Okay, this person contacts us from California. He says, I'm 62 years old and started drawing on Social Security, which is a minimal amount per month because I hadn't worked for many years due to various physical ailments. This month, I received a letter from a debt collector about some federal student loans that I believe from about 20 to 25 years ago. I'm currently attempting to qualify for Social Security disability because I've been unable to work for years. I'm in need of full-time. He's got all these medical issues. I've yet to be diagnosed completely as disabled till after I see a Social Security appointed doctor. So I'm in need of, we've got an appointment coming up in April. So I'm in need of legal advice about what options I have available and how to best handle the situation going forward. I'd like to just concentrate on my health issues and not be concerned about having what little I receive being garnished or being sued. If you can assist me in any way, I would appreciate it. They're not going to sue you on the student loan. And then last June, they haven't been setting off. Previously, before 2018, the government was able to set off 15% of your Social Security to pay a past due student loan. They really haven't done it since then, and they were going to start last May, but then a month later, the Department of Education announced that they weren't going to do it. They weren't going to offset 15% of Social Security for past due student loans. So, and they're not going to sue you. They don't do that. So this person, we're going to tell them that they can concentrate on your health. You don't need to worry about the stupid student loan. And when you qualify for disability, you'll be able to get on the disability will cause them to waive what you owe on the student loan. And we have an email that explains how you do that. Katrina says, I don't understand why my score isn't going up after 4 years. I hold no balances. My payment history is 100%. What gifts? Um, we don't, helps doesn't help people restore their credit. Okay, but we do have a company we pay them money to each month that will help clients that have been part of helps for 90 days help rebuild their credit. And so Katrina, you can call helps. We'll send you an email. You can enroll in that program. It doesn't cost you anything, and they should be able to help you rebuild your credit. My friend is 56. Can you get help still working a regular job? Well, maybe if they had a spouse that was on Social Security or a pension, or maybe if they were drawing a pension or Social Security and working a regular job and they had additional income. Okay. So you can call helps and we can re-enroll you in that 720 program. You can get re-enrolled if there's a problem. Person contacts us from Florida. I need help getting out of my lease to get a lower rent. I owe $6,000 in debt, but no credit card debt. Need help in getting rid of it. I need help getting Medicare caretakers. I have severe illness, severe physical issues, which is limiting me from working and doing housework. Also, in general, can I hardly lift or move some days. So they've got a lease and they want to get lower rent. Depending on your income, we always tell our clients to look at, and we have an email that talks about signing up for what's called Section 8, which is government subsidized housing. Now, a lot of areas there's a waiting period. Most places there is a waiting period. There is part of the country where there isn't a waiting period. And sometimes I'll tell people, they say, well, I don't really want that. I said, well, it may be a good idea just to sign up anyway and get on the waiting list, because maybe in 2 or 3 years, if they call and they offer you to be on Section 8, which costs you a quarter to a third of your income for rent, you might be very glad that you applied for it when you did. Okay. But this person, we talked to them about what their options is for lower rent, but they're not going to have to pay their $6,000 in debt. Okay. Eric said, I've done the program, no disrespect, it's done nothing for me. I'm doing it on my own. Yeah, none of these programs are perfect. This one's pretty good, though. He gives good ideas and he helps people. You got to be kind of persnickety about following his advice. And sometimes it takes a couple of years to rebuild your credit. But we got a lot of helps clients that tell me that after they enroll in helps, their credit just starts going up on its own without them doing anything. One thing I do know, that your credit is based on your recent credit history. Once a debt is written off as uncollectible, or you know by the credit card company, that's it. And then your credit is based on your recent credit history, recent credit that you have. Okay. So you can rebuild your credit. Now, you might say, well, Eric, what happens if I'm sued? If there's a lawsuits and judgments don't appear on credit reports anymore. Since about 2018, the credit bureaus stopped reporting that. So even if you have a judgment against you and you owe a bunch of money, if you got 2 or 3 judgments against you, it's not going to prevent you from building your credit back up. Person contacts us from Florida. I'm 63 years old, citizen. With over 20,000 credit card loans that I cannot pay anymore. I'm retired and receive $1,300 monthly. Call helps. You won't be judged by us. You're not going to have to pay the 20,000 in credit card debt. All the money you get, you're going to be able to use for your food and your medicine and your needs. Okay? Even if you got a pension, it's going to be protected, IRA, 401k. What about if you're working? Well, there's a federal law that protects a minimum of $217.50 net per week in wages in every single state. $435 every 2 weeks, $950 a month. And then some states don't even permit garnishment of wages. Texas, and some states protect a lot more than $217.50. California, Arizona, Nevada, depends on the state. So, a lot of our clients do work. Okay. So Kathy says, I didn't do anything and my credit is slowly going up, but I've been with helps for 2 years and 4 months, but it's still all fair. But my age, I'm not, most of our clients aren't worried about rebuilding their credit. For many years, we didn't do anything about helping seniors rebuild their credit, but people kept asking about it. So 3 or 4 or 5 years ago, I contacted Phil Tyrone at 720 Credit Score, who has a good, legitimate program, and said, can you help our seniors? And he explained to me how he could help our seniors. And so we've made this program available to our seniors who are interested in it. Some of them want it. They want it maybe to improve their credit because of trying to rent a place or some other reasons. But the vast majority of our helps clients really aren't into rebuilding their credit. And the other thing too, if you enroll in helps and you've got a credit card you want to keep and it's a small balance, like I talked about at the beginning of the program today, you can keep that. You can keep that credit card and keep making that payment. So you can still retain credit with helps. Okay. Eric, in today's world, you need some credit just the way it is. Well, maybe. Some people just, we do have debit cards which operate kind of like a credit card that you can use it electronically that can help. Okay. What about eviction? Yeah, you want to try to avoid eviction. It could still cause a problem, but we have emails that talk about, renting and what to do. Okay. Person from Oregon contacts us. Oregon's a nice state too. Hello. I've been introduced to your system as I'm almost 82 years old in May, and I have only, it looks like Social Security is my income at $1,900 a month. Last year, I bought 3 professional websites. It's supposed to bring me extra income, but it looks like it didn't work out. Probably got taken by someone. I have a total of a little over 10,000 in debit in credit cards. One is Chase Bank for 7,500. Also has a debit card. She probably banks with Chase Bank. And a couple others she mentions. Unable to pay for these credit cards because my rent is $1,100 a month. Her income is $1,800 a month in Social Security. Also, she has to pay for medicines. I talked to someone at Helps who no longer is working here. I'm not sure who that would be, but I'm aware there is a monthly fee with Helps, and I would like to set up My credit cards are soon due and I cannot pay. Thank you. So we'll call this person back. She's not going to have to pay Chase. She's not going to have to pay these other credit cards. Now, apparently she banks at Chase because she says she has a debit card with Chase. If her only income is Social Security and gets deposited in her Chase account and she doesn't pay the credit card, you can keep the Chase bank account. And they cannot, under the law, offset any money out of your bank account to pay the Chase credit card. Now, if it was a credit union, you'd want to change to a different bank, but not Chase. You could keep the same bank if you want to. Don't have to. Okay. Person contacts us from Florida. Hello, I'm 63 years old and retired. I just received a summons for court due to unpaid medical bills. I've seen some of your YouTube videos and wondering if I'm protected from garnishments in court judgments, being that I'm 63. It doesn't matter the age. It matters the source of your income. If this person is 63 and retired, they're getting Social Security or a pension, their income is protected, and they've been sued. No, if they get a judgment, they can't take your money. And if your Social Security gets deposited in your bank account, that means that twice the amount of Social Security you get each month is automatically protected from garnishment by your bank, regardless if there's other monies in there. So no, you're not going to need to worry. Okay. Sorry if this is a personal question, but I'm curious. Has your practice ever been in jeopardy of being erased? Creditors giving you a hard time? No, no. See, I'll explain. We don't give legal advice, we give legal information. And what we do is represent seniors and disabled persons under a federal law called the Fair Debt Collection Practices Act to receive debt collector communication. That's what we do. So when you enroll with HELPS, we send a letter to the creditors you owe money to, and they have to leave you alone. Okay? Do I have to be a member of the Bar Association to be able to send that letter? Well, I'll give you an example. Let's say I was a debt collector. Okay, the law states that if you're a debt collector, and I represent someone to collect a debt, I can send a demand letter to a person that lives in a state where I'm not a member of the bar to collect that debt. Okay, so if I, as an attorney in one state, can send a letter threatening a lawsuit and demanding a person pays money to someone in another state, that doesn't keep. I can do the same thing as an attorney in one state and send a letter to a debt collector saying, hey, I represent this person to receive communication. You have to just communicate with me. So no, we're not going anywhere. Creditors don't give us a hard time. They don't give us a hard time. They know, debt collectors know that if you're represented by an attorney, they have to leave you alone. We've got tens of thousands of clients. I'm not going anywhere. We should be a lot bigger than we are, that's for sure. And someday I believe we will be. Maybe sooner than later, who knows? People need to know about HELPS. We're the only law firm really that does this kind of thing. Because one reason other attorneys don't do it, the fees we charge are so minimal. Okay. So I talked to someone today and he wanted me to mention an ABLE account. That's an account you can deposit money into to help be able to pay medical bills in the future. I believe, and it's protected up to $100,000. We don't run into that very often. So if you have an ABLE account, it's protected. No one's going to be able to garnish it. Person contacts from Ohio. I'm 72 years old and have credit card debt that I owe $10,000 on. A company called Warden and Associates mailed a letter that said they are a credit card. Are a credit card debt forgiveness company. I said I had to say that I had to pay them $130. Then another company billed me $185 as their collection agency. Global Holdings LLC. They said they are a federal regulated company. I had to give them my banking information. Can you help me out? You don't need to pay them anymore. There are so many scammers out there, and and there's a lot of attorneys that in this type of business that operate little scams of some sort. You know, they do everything legal, but it's just on the on the fringe. Um, I don't know if it was in The Godfather or wherever I read the saying that someone said that an attorney can steal more money with a briefcase than anyone else can. And it's probably true. This person asked, do you need to have an account with a major bank, or is a credit union okay? I have 3 banks and I want to use only the credit union. So here's the deal. Um, the credit union and banks are covered by the same law. Okay, they're covered by the same law. So if you have an account with a credit union and you get sued and there's a judgment and your credit union account gets garnished, the credit union has to examine your account and protect twice the amount of federal benefits in there. Now, the only way they're going to be, credit unions and banks are different in a couple of different ways. If you bank at a credit union and you owe them money, whether you realize it or not, you gave them permission to take money out of your bank account to pay a debt you owe them, where a bank normally doesn't do that. And if you owe a credit union money, uh, you're going to want to change to a different bank if you're not going to pay the credit union. Okay. The only other problem with the credit union is this: if you owe, let's say you have a credit card, you have a credit union account, and let's say uh, you're buying a car from the credit union, and you have a credit card with the credit union, and so you say, oh, okay, I want to keep the car, but I don't want to pay the credit. I don't want to pay the credit card with the credit union, so you stop paying the credit union credit card bill, and then you change to a different bank, so your Social Security is going to a different bank, but you keep making that car payment. Whether you realize it or not, you sign what's called a cross collateralization agreement with the credit union. That tells the credit union that if you have another debt with the credit union you don't pay, that is also a lien on the car. So if you keep paying your car payment for 3 or 4 more years, and then all of a sudden it's paid and you ask for the title, they might tell you, hey, we're not going to give you the title until you pay the credit card debt. So you need to talk to us about that. That can be a problem. Okay? So Ms. H asks, when a help sends a cease and desist letter to an attorney suing a client, we don't call that a cease and desist letter. Okay, we just call that, it's kind of a courtesy letter to the attorney, letting him know that our client's income is Social Security. They're not going to pay the debt. We understand they're going to get a judgment. They can still proceed with the lawsuit and get the lawsuit. And yeah, it explains clearly that we don't represent the client in court. It says, by saying that, will that encourage them to continue to bother a client? Well, we already talked a little bit today about how sometimes they might dismiss a lawsuit. That's unusual, but it does happen. But they usually run these things through artificial intelligence. They're just simply going to get the judgment. Okay. But we're here to answer our clients' questions if they get other follow-up correspondence from the judgment creditor. But you don't need to worry. If your income, Social Security, or pension, disability, like our talk, is protected, you could have 100 different creditors sue you and get judgments. Your income's protected. You don't need to worry. Okay. We're running near the end. here. I just received a letter from a debt collector law group asking me to reply back with a dispute uh, by a certain date. I am a senior and only have Social Security benefits, nothing else. How should I respond to this letter? Tell them that my income is protected and I know my rights, or please advise you. Well, you could do that if you want. You probably don't need to do anything. If you send them that letter saying your own income is Social Security, I don't know if they're even going to read it. But, you know, a lot of times you don't need to communicate with the creditor, uh, period, about the debt, because sometimes they can manipulate seniors and, you know, twist words and scare them into thinking they can do something and end up the senior ends up paying on a debt when they really don't have to pay it. So you can always call and talk to us about your situation. We don't want you to worry. Okay, we're getting near the end. Oh, I like this one. Person writes, there's a comment on one of our videos or some video we did, and it says, yeah, but what if I'm grossly negligent? Do you still want to take my case? Um, and I'm not laughing. I think I answered him. And what I would have said was, it doesn't matter the reason you ran up the debt. It doesn't matter. We're going to help you. I don't care the reason. No one's grossly negligent. You know, I've been doing this long enough to know that seniors don't intend to get in these financial problems. Life just takes them there. They don't run up this debt with the intent, I'm going to run up all this debt and now I have to pay it. I'm going to contact help 3 years or 5 years from now. No, they don't. No, it just happens. A spouse passes away, you lose a job. Maybe you helped a kid out. Maybe you got taken advantage of. Maybe a spouse passed away and now you're on lower income. Maybe you had a little side job, you no longer can do it and you just can't pay the debt anymore. Maybe you used some protected money to pay up the debt and now all of a sudden that's gone. It doesn't matter. You're not being grossly, we have emails that talk about guilt and debt, why you don't need to feel guilty. And so, no, you contact us and we're going to help you. We don't turn anyone away that needs our help. A lot of people get our help for free. They do. We don't want to be able to help you. Maybe one or more, and then we'll be done for today. But we'll be here tomorrow. But what if I'm on Social Security, but work a part-time job, which is not much at all, but helps, but I only work 29 hours at $12 an hour? Is that protected? Well, let's see. 29 hours times 12 is what? Um, about close to $375 a month. Now, what's the net? Maybe 325. Is that protected? Well, depends on the state. For a week, 217.50 in every state, but some states like Texas don't even permit garnishment. And then someone would have to sue you, get a judgment. They'd have to know where you work. So the chance of you being garnished, we have a lot of helps clients, not a lot, but we have some that still have a part-time job. We don't have we don't see problems very rarely with them being garnished on that part-time. The creditor would have to sue you and know where you work. Yeah, I mean, you could lower your income so it's protected if they were to start a garnishment. In certain cases, we might be telling you to consider filing bankruptcy, wipe out the debt and working more hours. So no, don't need to worry. So it's been an hour. I want to thank you for your participation today. I will be here tomorrow, same time. And in the meantime, press the like button. If you have any questions, you can put them in the comments. I like to look at those, maybe answer them during the day. But you can always call us toll free, 855-435-7787. Subscribe to our channel. More people that find out about helps more people we can help. And so the more people that enroll, make comments, and participate in some manner, uh, the better it is. More people find out about it. So God bless, and I will talk to you guys tomorrow. See you later. Bye.